As a litigator with 16 years of experience in court, I've witnessed countless technological shifts in our profession, but nothing has been quite as transformative as the use of artificial intelligence in legal practice. I know a lot of people who talk about it, they do a surface level discussion of AI hallucinations in court filings. Instead of simply warning you about the dangers or citing the same cautionary tales everyone else is sharing, I wanted to explore the structural reasons behind increased hallucination rates in newer AI models. I wanted to analyze how these hallucinations manifest in complex litigation. I want to share my own framework for effectively incorporating AI into high-stakes litigation practice. So I want to talk first a little bit about the counterintuitive evolution of AI hallucinations. So what most commentators miss in discussing AI hallucinations is a technical paradox at play. Recent reporting in the New York Times, and that's really what prompted me to do this video, highlighted something that seems counterintuitive. So the newer, more powerful AI systems are generating more errors, not fewer. And this isn't a failure of technology, it's actually an inevitable side effect of how these models are evolving. So let me explain why this matters for litigators. So the first generation models, the early versions of GPT, were essentially sophisticated pattern matching systems. They excelled at regurgitating information they'd seen during training, but were limited in their ability to synthesize new insights. The newest reasoning models, like OpenAI's O3 and O4 Mini, they're designed to think more abstractly. So they're designed to perform multi-step reasoning tasks and draw connections between different domains of knowledge. This makes them more powerful for complex legal analysis, but it comes at a cost. Each step in the reasoning chain introduces an opportunity for error, and these errors compound. So when the model is asked to show its work, to explain its reasoning, it's effectively creating more surface area for hallucinations to emerge. This explains why OpenAI's most advanced models hallucinate at rates of 33% to 79%, depending on the test type, significantly higher than their predecessors. Even specialized legal AI tools from LexisNexis and Thomson Reuters, they still produce incorrect information about 17% of the time. For litigators, this creates a dangerous trap. The more sophisticated the legal reasoning required, the more likely AI is to fabricate information while appearing increasingly confident in its accuracy. So the case analysis beyond the headlines. I said I wasn't going to do this, but I'm going to do it a little bit anyways. There are 3 recent cases where AI hallucinations led to legal sanctions, but I want to focus on the technical and structural factors that contributed to these failures. So in one case, in Mata versus Avianca, an attorney, Steve Schwartz, used ChatGPT for legal research and cited 6 fabricated cases. What makes this case technically interesting is when confronted, Schwartz asked ChatGPT if the cases were real, and it confidently assured him that they were, demonstrating how models will self-reinforce their own hallucinations. Examining the actual AI outputs from this case reveals that ChatGPT didn't just invent case names, it created entirely plausible sounding internal citations, procedural histories, and quotations that mimic the argumentative structure Schwartz was seeking. This illustrates how AI hallucinations aren't random errors, but structured fabrications aligned with the user's intent. The MyPillow case that we've heard about a little bit more recently is particularly revealing when viewed through the lens of rising hallucination rates. Mike Lindell's attorney submitted a brief with nearly 30 fake citations that were generated using Claude AI, which is an AI system that a lot of attorneys are using that promises to have more privacy controls in place, meaning you could put confidential information in Claude AI and they won't use it to train their model. And this is a system that is specifically designed to reduce hallucinations, yet it still produced extensive fabrications demonstrating that even safer AI systems remain fundamentally unreliable for legal citation and legal research. What's most instructive about the MyPillow case isn't just the initial error, but the system failure that followed. So the attorneys didn't catch the issues for 55 days, suggesting that AI-generated content has become so stylistically convincing that even experienced lawyers struggle to identify fabrications without independent verification. Um, as an aside, the judge had, in that case, I understand, had filed a show cause hearing or something like that, and basically, I think the attorneys in the MyPillow case said they were so busy they couldn't really respond to it because of, I guess, the sanctions or whatever the judge was doing. They created the issue. The judge was asking for a response, and they said they can't because they're just so busy dealing with the judge's problem. I forget exactly what it was, but um, I think when a judge asks you about these things, you basically have to fall on your sword and admit what you did. I think they said it was a draft, I believe, and then the judge asked them to provide the metadata to show that the AI generated citations were just a draft that were accidentally filed. So it's really concerning when a situation like that arises because you just don't want to be caught lying to the court. And I'm not sure how that's going to shake out. I think that's still pending right now. There's another case that happened this year. The Morgan and Morgan case from February 2025 represents the most concerning evolution. This is an established law firm with over 1,000 attorneys. They developed their own AI tool specifically for legal research, yet it still hallucinated case citations. This directly challenges the assumption that proprietary legal-specific AI will solve hallucination problems. Um, I myself have been trying out different AI solutions for lawyers, and I still have not come across one that can confidently and reliably save you the time that it promises to do so. I think they're great for outlines. I think they're great for brainstorming. Um, Sometimes they'll give you some cases that will point you in the right direction, but I think a combination of secondary sources is a good place to start. That's what they train you in law school to do, read legal encyclopedias and um, CGAs and other ALRs and other broad places where you start your knowledge of the law, learning about a topic, and then you can kind of dive in and go deeper. But I just don't think AI is ready for any real heavy legal drafting. It can fill in the blanks sometimes, but you're going to have to find those citations and review them, check the quotations, check the pin sites, make sure that things are accurate. The court sanctions in the Morgan & Morgan case were particularly notable because they emphasize that the rise of AI does not change an attorney's fundamental obligations under Rule 11. Technological advancement doesn't alter our professional responsibility framework, it amplifies it. And I think that's the danger that people warn about, is that you have these tools, but you don't really know how to use them. Yet people expect you to use them. And that's what I want to get to next, the systemic pressure driving AI adoption. So to understand why attorneys continue to use these systems despite the risk, we need to examine the structural economic pressures facing litigation practices today. So the legal fundamental market has fundamentally changed. The legal services market has fundamentally changed. Since 2008, we've seen a compression of billable rates, especially for discovery and research tasks, while the volume and complexity of litigation just continues to increase. Clients are demanding more for less while expressing decreasing willingness to pay for associate time spent on document review and legal research. And this creates tremendous pressure to adopt technology that promises efficiency, particularly for solo practitioners and small firms who lack the institutional support of large firms. And even large firms, you would think large firms or governments or other institutions that have support, um, it can be difficult to coordinate those resources, train people, and deploy them effectively. So many attorneys turn to AI not out of laziness, but out of economic necessity. And because their clients expect it. If the tool exists, if online legal research exists and a lawyer is billing more time to go to the library and actually pull out books and look up things, the client's going to be upset. They're not going to pay for that when there's a more efficient solution available, and they believe it exists, and lawyers are going to have to figure out how to balance the client's desire for efficiency with the lawyer's duty for accuracy. Meanwhile, courts have significantly shortened briefing schedules over the past decade, with many federal districts reducing standard response times by 5 to 7 days. This compression creates situations where attorneys must produce comprehensive, responsive briefs in timeframes that traditional research processes struggle to accommodate. A lot of these timeframes are assuming like that's the only matter you're working on, and the reality is that attorneys are working on bigger caseloads because they're charging less, trying to be more efficient, and it's just the economics of law practice that are pushing people to do more with less time. These systemic pressures create a perfect storm, so the attorneys need AI to remain competitive, yet the technology remains fundamentally unreliable for core legal tasks. Um, so here's what I do with AI, and this could be helpful for litigators. Everybody has a different perspective on it. As a practicing litigator who has successfully integrated AI into my practice, I am acutely aware of hallucinations. I really do my best when drafting work to avoid them. Um, and what I do is, first of all, here are the couple areas that I use it for. So first, I use it for case theme development and testing. So AI helps me explore multiple potential case theories early in litigation. I'll input the key facts into an AI system that doesn't share that information outside, doesn't use it to train its model. And I'll ask the AI to generate 5 to 7 different ways to frame the central narrative. And sometimes I'll input basically what I think is a good narrative or a good theme for the case and ask it to consider other thoughts. And so basically, it's like talking to a colleague um, and trying to get a framework on that. I'll do that with AI, but I'll actually talk to other people as well. But it's my starting point before I start talking to other people and taking up their time. This diversity of perspective helps me avoid cognitive tunnel vision without risking factual errors, since I'm not relying on the AI for the facts, just for creative framing. And for each potential theme, I ask the AI to identify potential weaknesses or counter arguments, and this helps me pressure test my thinking before committing to a strategy. Again, I'm not using the AI for factual or legal research, just as a idea creation partner. And this is really helpful for solo practitioners who sometimes just struggle with the idea of the whole case sitting on your shoulders. It is, in a way, kind of like a therapy in the sense that you're able to talk to a virtual person to figure out ideas in your case. The second thing that I do is preparation for depositions. In preparing for depositions, I'll use AI to generate alternate question sequences, identify potential evasion strategies a witness might employ, and this complements my traditional preparation without creating hallucination risks. So, one of the things that we do as lawyers is we're trying to anticipate how something might go and what are the potential branches, right? It's like playing chess, trying to think 3 moves ahead. And that can take a lot of time if you're doing it on your own. You can also outsource those different possibilities to AI and prepare plans for the different ways a witness might wiggle out of a question, and also can help you prepare traps for questions where you may want to get the client going down a particular road. It'll help you funnel those questions. So I find this helpful for identifying blind spots in deposition outlines where my own biases or assumptions might lead me to overlook important lines of questions. I also use it for, the third thing I use it for is document organization and pattern recognition. So for large document collections, I'll use AI to suggest potential organizational schemes or identify recurring patterns or anomalies across document sets. This doesn't replace human review, but it provides a valuable first pass organization that makes human review more efficient. In the context of just general document review, there might be some key documents in medical records that I need help identifying, and if I ask it to look for specific things instead of a standard keyword search, I can ask it to say, like, this is what my case is about. I'm looking for specific injuries or treatments, or to rebut, something that an expert might be saying, or the other side. What would indicate that? And it'll give a quick cursory glance, and of course I'll be looking over those documents a little bit more closely, but it gives a quick overview, and it summarizes information effectively, and so that's something I'll use it for. I also use it, the fourth thing I use it for is strategic motion evaluation. So before filing a motion, I'll use AI to analyze the strategic impact of different motion types. For example, when considering whether to file a motion to compel or a motion for sanctions or simply a strongly worded letter, I'll ask AI to evaluate the likely judicial and opposing counsel reactions to approach based on specific judges and then opposing firms. So that will require like a combination of sources. It may require pulling stuff from public records from court filings to see how the opposing firm or judge rules on things, inputting that into the AI system to see what kind of language they use, how the judges rule, and then putting my specific briefing in there, or basically saying, like, for some people that are experienced, they'll already know this answer, but for somebody like me, I'm still working on my civil litigation side. I've done quite a bit of criminal prosecution and litigation on that side. But on the civil side, just trying to anticipate, what type of tone that I want to set in my litigation strategy, and basically trying to find that line between being a being an advocate for your client without being a jerk. So I use that for basically to temper, what response I might get, or how I want to approach a situation so that I have a particular type of response. It offers a second opinion, right? And then, of course, you'll talk to somebody else who's been practicing for a while. They'll offer you an opinion, and then you ultimately have to use your own discernment to decide what kind of lawyer you want to be and how you want to practice and how you want to manage your reputation. But it'll give you different possibilities and different thoughts on that. And sometimes I already know that, but sometimes it might offer me an insight I haven't seen before. Fifth thing that I use it for argument structure optimization. So in brief writing, I use AI to optimize the structure and flow of arguments after I've already identified the relevant legal authorities. So, in my legal research and writing, I'll tend to put authorities that I find that are relevant to my case. I'll put quotes in there, and I'll have a general idea of where these cases should be placed in the argument structure. But sometimes when you're organizing a brief, it may not make sense where you're putting it. You just don't realize it because you've been with it so long. So normally you would get some other attorney, you would put the brief down, come back a day later and have someone else look at it, and they might take some time to review it. But AI gives you a quick review on these more complex arguments and complex briefs, and they may give you transitional language to help improve clarity. And those little things, that editing that we have a really hard time doing, AI can be really useful and a value-added service there. And then also for citation and reference verification. Now, I don't use AI to identify legal citations, and it's very unreliable in checking your citations. But one of the things that you can do with AI and citations is basically ask it to check if there's certain statements that you've made that you don't have a citation for, that might be unsupportive. And I try the best I can to, every time I'm making a statement, to have a citation. But it might point out if you're making too far of an argument without having supporting legal authority. So it's good for identifying gaps in your citations. And then finally, number 7, I use it as a communication enhancement. We've seen a lot of this with Apple's advertisements for their AI system. But for routine client updates or emails that I don't want to draft and send, or it's at the end of the day or beginning of the day, I'm not quite woken up, I might basically have a prior email response that I want to just say, hey, AI, how would I respond to this? Just help me crank out an email really quickly that basically says what might take me a few minutes to think about. It'll just generate it for me while I'm busy doing something else. This saves significant time, but it also saves mental energy, and just like having cruise control on your car sometimes can help you focus on the task that you're doing and driving without all the minutia. I think it's a useful tool to have there. So the future of AI in litigation, I want to go there. Despite the hallucination challenges, I think that part of it will continue to get worse until they figure out new reasoning models. I'm optimistic about the future in AI and litigation. I think the technical limitations are well understood and being actively addressed through retrieval augment generation, which anchors AI outputs to verified information sources. I think AI is going to get more expensive as time goes on. A lot of the information that they're training on is usually public, or they have to pay a lot to get access to those databases. I think it'll get more expensive, but I think it will get better over time. The legal specific AI tools are evolving rapidly, with newer systems designed explicitly to indicate uncertainty rather than hallucinate when faced with knowledge gaps. And most importantly, the profession is developing a clear ethical framework and best practices for AI use that will eventually standardize how we integrate these tools responsibly. I think a couple of months ago, the State Bar Texas Litigation section put out a journal just on artificial intelligence and law practices. And I think the more we see it, the more people will use it. And obviously, we're going to hear about stories about people not using it the right way. And there's going to be mistakes, but eventually it is going to be a part of our practice. And the ones who use it effectively are going to be able to increase their productivity. And just generally in economics, if we're able to um, have a way to invest into these resources and these tools that make us more productive, the more productive people are going to get a bigger share of the market. They're going to make more profits. They're going to be able to exceed all the people who essentially stick to the old ways. They'll still find a place, but it'll be something like, I don't know, like the difference between an artisan versus somebody who is mass producing information. I think AI is going to hopefully democratize, um, not democratize, but rather make access to justice easier in the sense that younger attorneys with limited experience can use AI as co-counsel in their cases, maybe experienced co-counsel. So a single solo law practice can essentially operate without the overhead of multiple attorneys reviewing a document. I think that's promising, and that could result in lower rates, but it also could result in a race to the bottom. It really just depends on where we position ourselves in our practice. So again, in conclusion, the paradox of AI in litigation is that its greatest promise, helping us manage complexity and scale, is where it presents its greatest risk through hallucination. So the more complex your matter, especially attorneys and people who work in complex litigation like I have done in the past, we do look for those easy outs, but I think that's still going to be a very human intensive endeavor. It's still going to be expensive to do complex litigation because AI hasn't quite figured it out reliably to help out. As litigators, we do need to develop nuanced approaches that leverage AI's strengths while implementing structured safeguards against its limitations. So this could be policies about when we use it and when we don't, or even just how we use it in certain situations. It's not the wholesale adoption or rejection, but strategic integration with our professional obligations. I hope the framework I've shared gives practical guidance on incorporating AI. As the technology continues to evolve, so too will our approaches to using it effectively. If you found this helpful, please subscribe for more in-depth content or navigating the intersection of technology and litigation practice. And I'd love to hear how you're using AI in your own practice. Share your experiences in the comments, and hope you have a good rest of your day.